So, first of all, we better figure out how to use this. All right. So, as a divorce attorney, I just want to start with a question. What do our clients hire us to do? And I'll spend a little dead here. No, a lot of response, but I'm going to look for a little bit of responses today. So you're going to have to help me out, especially if there's not a lot of people yet. I'm going to look for response. So who can help me out? What do our clients hire us to do when we're taking a divorce case?
Look out for their best interests.
Great answer. Thank you. Anyone else? No wrong answers with this question. What was that?
Answer questions.
Answer questions. Right. They have a lot of questions, so that's great. Anything else? Yes, right here.
They expect us to do everything that they want.
I really like that question. Who hasn't had that experience? I would assume that everyone has. So they're looking for a lot. As attorneys, we clearly do a lot for our clients. Let me switch to this. We clearly do a lot for our clients. And so it's good to know exactly what they're looking for and what they're going to want when they hire us. Got a little layout that sort of shows what we do as a lawyer. Top right, what my friends think I do. Top middle, what my mom thinks I do. Fight for what's right. I think sometimes she'd be surprised at what I actually do. Top left, what society thinks we do, which is eat money apparently. Bottom right is what I think I do, which is argue very sophisticated. Middle, what our clients think we do, and then the bottom left is what I actually do most of the time. So I would say our clients want us to do a lot, but when we're talking about a divorce, ultimately what it comes down to is they want us to do everything. And so what I'm going to focus on today is one aspect that a lot of times as divorce attorneys, I don't think we pay attention to as much as maybe we should, and that is contracts. And the reason for that, I believe, is at least for most divorce attorneys, I think they tout themselves as, hey, we're litigators. We go to court and we argue. I know me, I wear my litigation as a badge of honor. I'm a litigator. I'm not a transaction attorney. I'm not boring. I go to court and I litigate. But in reality, what happens is that in litigation, the majority of our cases settle. I know in my experience, probably about 95% of my cases settle. I think on a good year, I think I've been down to 85%, but the majority settle, which means the majority of our cases are resolving through a dissolution agreement. Now, is anyone else different here? Does anyone else go to trial on 100% of their cases? Anyone, just raise your hands. I'm assuming most everyone's in the same boat as I am. The majority of the cases are going to settle outside of court, which means it's great because we're litigators. It's good to learn how to be a great litigator. But in reality, because the majority of the cases settle through some kind of dissolution agreement, we've also got to know how to draft those agreements well and do it good for our clients. So we're going to go through that a little bit. It's going to throw us back a little bit to law school. I know I focus my practice a lot on litigation. And so when I started doing a lot of divorce cases, what ended up happening is I got a rash of a lot of divorce modification cases. I felt like there's 6 months where I don't think I did a single divorce during about 6 months. It was always divorce modification or contempt. And what I started realizing is a lot of those cases should never have gotten to that stage. If they would have had a good and well-drafted dissolution agreement to start off of, they could have completely avoided ever getting to the stage of the modification or a contempt issue. So I started taking notes as to what needed to happen. And it shocked me at some of the things that us as attorneys missed. And so what I'm going to do today is we're going to take that step back. We're going to talk about some of the basics of what we need to draft a good litigation or a good divorce agreement. So to start off, we're going to go through some of the basics. All right. So the two greatest contributors to contractual disputes are, first, failure to address all possible situations. Now this can occur for a whole lot of reasons. But what I was seeing in a lot of those contracts was that when Probably the biggest thing that was being litigated was because either the attorney did not include something, or maybe the client even didn't want it to be included because they thought it wasn't an issue. So first of all, we've got to make sure that everything is being addressed in our agreements. And the second thing is ambiguity. If you remember back in law school, remember that when you're talking about a contract, if there's ambiguity in a contract, it can be found void and it can be unenforceable. And so you've got to be very cautious with ambiguity. So we're gonna go through a lot of these things, but keep in mind that those two things we've always got to have our mind forward to when we're drafting a dissolution agreement. And what I suggest is we want to have a way of doing it that we always want to be doing the same thing, always want to be going through the same processes when we're drafting these agreements, so that we ensure that we're not missing anything, that we're not failing to address something, and then we've got to be aware of the ambiguity so we don't miss anything. We're going to start with some general contractual advice. First of all, very basic, be precise. Right? Being precise entails a lot, obviously. We could probably spend a whole CLE session about how to be precise in a divorce agreement. Obviously, we don't have the time for that. And I want to touch on a bunch of items. But being precise means being accurate, being complete, being exact, clear, specific, and focused. All right, but what I'd suggest to you is one of the most important things about being precise is you've got to know what you're talking about. So you've got to have that background knowledge of what you need in that agreement so that you're not failing to address something. All right, what I'll start out with is maybe an example of what not to do. So this is an example of what not to do in a divorce agreement.
It's not going to be easy. My brother and I. And then, have you never done synchronized swimming in a sanctioned competition in this country? Officially, it's got, like a 0 or something.
I don't swim.
So of course not. Nobody's just going to walk up and hand us a gold medal, especially since men's synchro isn't even in the 88 Olympics yet.
But that's okay, because we could use the time. Because I'm not that strong a swimmer.
But I mean, that just means that, 92 or a watch for the gold.
All right, so now that I've got your attention, who here has someone they know that practices law that maybe that reminded them of? That maybe they jumped in the deep end and they don't really know what they're doing. All right, so that's what I'm talking about. When I'm talking about you've got to know, you've got to have that knowledge base, so you do it. I saw some head nods, so hopefully it's not you. I doubt it is. That's why we're here, though. And what I'd suggest is that what we'll do today is we'll go through what we need so that that's not us. We don't want to be the person that is jumping in the deep end and doesn't have that knowledge base we need to. We need the knowledge to be precise. That's the bottom line. We need that knowledge. So what we'll do today is we'll go through a lot of that. Now, this is more of the 101 course. Now, just to be clear, this is my caveat. This is more of the 101 course. We're going to go into some of the basics that we need to do what we have to. We're going to go through the basics of the knowledge. This is not going to go extremely deep. What I'm going to do today is I'm going to talk about the basics, and what I'll suggest to you is if you need deeper knowledge, go seek it out. But this will give you the basic idea of what you need to look out for when you're drafting these so that you have the knowledge you need and you don't have to worry about being that guy that everyone looks at and thinks, man, he does not know what he's doing. So don't be that guy. All right, so the next advice, you got to balance the precision with simplicity. Obviously, we need to be precise, but we also need to be simple. So who here has been in a situation like this? In their office, the boss comes in, asks them to draft, or do another draft of an agreement. because there's still a couple of sentences that might actually be understood. I'll tell you, when I was first out of law school, I thought I was awesome. I mean, who doesn't at that age, right? Young, energetic. I just graduated from the University of Alabama, Roll Tide. I graduated well, I got a great job, go to my first office, and the managing partner gives me a big drafting assignment. I think, all right, I'm going to knock this out of the park. I'm going to do awesome, and everyone's going to be so impressed. Well, I drafted what I thought at the time was a great agreement. And a couple days later, I get back the draft, red marks all over it, a bunch of marks, and I had done a terrible job apparently. But when I read through it and saw his revisions, he included so many legalese and so many, to be honest, words that I had to go through it with a dictionary because I just didn't understand it. And I thought I was pretty smart until I saw that. That I was surprised that anyone understood it. So, very frustrated, obviously, but I learned something from that. And what I do now is I look back at that and I say, all right, well, I got the last laugh. Even though I felt like a fool then, I got the last laugh because that is the age of the dinosaurs. We don't do that anymore. We don't want to sound like the attorney that knows everything, right? That uses such big language that nobody understands it. We want our clients to understand what's put in the agreement. If they don't understand it, I can guarantee they're going to be on the phone every time there's a question about their decree of divorce. Hey, Doug, what does this mean? What am I supposed to be doing? We don't want that. We want it to be very simple. Simple terms so that we can understand it and so that our clients can understand it. Next, use plain English. This may be a given. I happen to be an English major for my undergrad, so I'm a little cautious about this. But first off, don't use any jargon. It doesn't make sense. I'll tell you, when I first got married, I would come home and I'd talk all the time with my wife, hey, this was happening at work. And finally came to the point where she said, Doug, I can't take it. I don't know what you're talking about half the time. I'm not following what you're saying. Because I was using all the language that us as attorneys think is normal, but the layperson just doesn't get. So we want to make sure that we're not using language that our clients aren't going to understand. And the reality is, my wife's a very intelligent person. But she still had a hard time following me because I was so used to speaking in that legalese. So don't use the jargon of attorneys. Obviously we have to use some that you've got to put in the agreements. But you want to put it in as basic terms as possible. And not only that, but use proper English. So one of my pet peeves is when people confuse things. First off, be careful with will, shall, must, and may. Remember, some are permissive and some are commands. I'll tell you, I have seen enforcement cases be lost based upon a simple word. A must was replaced for a shall, a shall was replaced for a must. No, a shall was replaced for a may. See, now I'm even confusing myself. You've got to be careful with these. You've got to be careful. Because it can kill the case if there's ever an issue down the line. So you've got to make sure that you're very careful with this type of language that makes a big difference in a divorce agreement. And the other thing, avoid words with more than one meaning. Once again, the second little item that I told you about, avoid ambiguity, that's exactly what these cause. And so there's a lot of language that can have more than one meaning. And what I'd suggest, probably the biggest thing that I've seen, bi-weekly. I mean, twice a week or every other week. Maybe this isn't a Missouri issue, maybe this is just Utah, but in Utah we see that all the time. Because we talk about what's going to happen every other week with the children. They use bi-weekly all the time, but then the courts have found that that's ambiguous because of the double meaning. So you've got to be careful with those type of ambiguous words. Next issue. Beware of form agreements. All right, I'm going to ask for some participation again. I'm starting to do this right after lunch. I know everybody's tired. Who here has used a form agreement? Stop. What was that, 5 people? I don't believe you. I bet you anything there are more people that have used form agreements. I would guess that almost everyone. Let me ask you a different question. Who has never used a form agreement? That's more like it. Nobody raised their hand, right? I gotta ask the right questions, right? So we do that a lot as attorneys. And I get it. We're trying to balance the costs of drafting a whole new agreement for our clients versus using something that we've used in the past. But I would suggest don't do it. It just causes too many issues. Tell you another story from when actually this was a couple years ago, probably about 2. I was involved in a very complicated case, and I got a settlement proposal from opposing counsel. And I read through it, and there was a custody section that when I read it, I just thought to myself, wow, this is beautiful. Everything is covered. Everything you could ever think of would be an issue in custody. It's covered. It drafts it nice. It's understandable language. I mean, everything that I'm telling you should do in an agreement, it was there. Except for one glaring thing. Anybody want to take a guess as to what it was?
No kids.
No kids. Thank you. It's funny because I gave this presentation to my wife a while back, and she's like, no one's going to know what you're talking about, but I knew someone would get that. No kids, right? Clearly, this was a cut and paste job. And this happens all the time. All the time. I've had a pleading that I've seen where literally it has a little bracket that says, insert awesome argument here. That was it. All right, so as attorneys, sometimes we do this kind of stuff, and I'll tell you, it is ripe for mistakes. That is not what our clients want. It's just not. Our clients don't want that to happen. So to help you remind that, I've got another little cartoon off an office building. Secretary calls or talks to the boss and says, someone calling themselves a customer says they want something called service. That's what our clients want. They don't want a form agreement that's not specific to them. They don't want a cut and paste job. They want something extremely specific that is for them, especially in a divorce. Divorces are extremely personal. And so what I would suggest is that when a client hires you, what they're looking for is they're looking for the personal service and attention. They're not looking for a form agreement. And there may be sometimes that you want to look at something, but don't do a cut and paste job and don't do a form agreement. Next, and this could actually be a subsection to be precise. Gather all the needed information and documentation before you draft. This is really essential to drafting a good contract. And like I said at the very beginning, when we talk about being precise, one of the most important things of being precise is we want to make sure we have all of that knowledge to draft a good agreement. Well, knowledge obviously entails knowledge of the law, which is what we're going through a little bit today. But it also entails knowledge of the case. We need to know the facts of the case. If we don't know the facts of the case, we're not going to be able to draft a good agreement. If you don't get all the facts, you cannot draft a good agreement. How we do that is we do that through discovery. So we've got to complete all the discovery necessary. So a lot of times, the very first thing I'm going to do is I'm going to draft up a list for my client of exactly what documents we need. And he's going to gather them. And then if there's anything that he cannot get from my list, we're going to do discovery on it. Because you cannot get it without it. And the reason why is because if you don't have that information, you can guarantee that there's going to be unanswered questions and issues will come up. How in the world can you draft a quadro if you don't have information regarding the retirement? You can't divide the debts if you don't know what the debts are. So you've got to have that information. You've got to have it before you even start drafting the agreement. In fact, as we talk about a little bit more of the specifics that we're going to be looking at in divorce cases, I'm going to harp on this multiple times. We've got to get the information before we even think about starting drafting a divorce agreement. We've got to get that information, period. So now we're going to go into a little bit of the specifics of what we're going to be, or of what you're actually going to be drafting in a divorce agreement. So first off, we're going to talk a little bit about custody. Custody is one of the usually higher charged issues in the case, emotionally charged. There's actually studies out there that show that when someone becomes emotional, they lose their intelligence to a point. They become less rational. And so what I would suggest is you've got to be that rational person when we're talking about custody for your client. So, every state's different, and like I said, I practice in Utah. So I just want to start with asking the question, what should you consider when you're drafting a divorce agreement in Missouri? Feel free, shout it out, let us know. What do you think should be considered when you're drafting a custody agreement in Missouri? Yes?
What is actually working for the family now?
That is great. That is very great. Thank you. Anyone else? Don't be shy. You don't have to get up. Just say something.
Holidays, including special holidays for the family.
Great. Thank you. That's a great one. All right, there's a lot. I can tell it's going to be hard after lunch to get this out of everyone. So I'll give you a hint. If you have the handouts in front of you, I've got a huge list. All right? Huge list. There's a lot to consider. All right? And I put these there because this is not all. There are a ton to consider. And so what I would suggest is you want to consider everything. Right? There's a lot to consider. So we don't have the time to go through everything. But there's a lot to consider when we're talking about drafting a custody arrangement. And like I said, this is one of the more hotly debated and thought over issues, and so we want to make sure we cover it all. Rule of thumb when you're talking about custody, the more detail, the better. You've got to have the detail. I actually had an initial consultation come into my office 2 weeks ago. I better get the exact language. He was in there for a modification. He had been divorced earlier this year. Literally, it was January that he was divorced. And his custody clause stated this. It said, petitioner is awarded sole custody with respondent receiving parent time as designated by petitioner. That's all it said. And so I looked at that and I said, well, no wonder you're in here. We've got to fix this. And the sad thing is, he was represented by an attorney. His wife was represented by an attorney. And yet, somehow, that clause was still entered into it. Now, I asked him, why in the world did you ever agree to this? And he tried to blame it on his attorney a little, which happens a lot, as we probably all know. But I think what it came down to is he basically said, well, we were working together well at the time. I didn't think I needed to put anything else. Who's ever heard that? Why should we go through the detail? There we go. Who hasn't heard that as a divorce attorney? I don't need all this detail. I don't need it because we're working well together. Now, clearly, they needed it. Because 2 months later, they were back in court, trying to deal with that poorly drafted clause. Quite honestly, I'm sad that the judge let that pass because it's very lacking. So, what do we do when the client doesn't want to take the time to go through and agree with everything? What do you do with a client like that? Obviously, you can relate this story and tell them, hey, you're going to deal with it now, or you're going to deal with it later. And that's just the facts. You're going to deal with it now, or you're going to deal with it later. Or, you could do what a colleague of mine suggested and send a letter like this.
We now deny for the 8th and final time. You must be stupid, stupid, stupid. Sincerely, Everett Lufkin, Vice President, Claims Department.
Has anyone here wanted to send a letter like that to their clients? You're laughing because that's a no, right? No one here would want to do that. So even if we want to do that, obviously we can't. In fact, you've got an ethics presentation here in a couple hours, and I can guarantee they're going to say, don't send a letter like that. But sometimes we want to, because clients often don't want to do the work necessary to get things done right. And if you remember here, what happened with Everett Lufkin is he got in a little bit of trouble. So don't do that, because you'll get in a little bit of trouble. But you've got to do something. What I'd suggest, first thing, you've got to warn the client of what the possibilities are. And one of the other possibilities of if you have an agreement like that is enforcement. How in the world do you enforce an agreement that says parent time is going to be as this party designates? I'll tell you, he came into the office wanting, I mean, he was the petitioner, so he was in a better position. But he came into the office thinking, oh, we're going to do an order show cause, we're not going to have to modify, we're going to be able to just nip this in the bud, it's going to be good. I sat him down and said, how in the world am I supposed to take an enforcement action on this? I could almost guarantee if I took that in front of a judge in Utah, they would look at me and says, Mr. Anderson, what do you want me to do with this? They can't enforce an agreement like that. The only agreements that they can force are the agreements that are clear and specific as to what the requirements are. Another rule of thumb with custody, and I said the more detail the better. Well, the more contentious the case, the better. Or not the better. Ugh, can't believe I made that slip. The more contentious the case, the more detail you need, period. But I wouldn't just leave it up to the contention, because like with this case that I'm telling you the example of, during the divorce it wasn't contentious at all. So you've got to be careful not to be lured into that by your clients. Oh, don't worry about it, it's fine. Don't fall for it. It'll be an issue. And like this client, I mean, he didn't go back to his original attorney. He thought his original attorney had done something terrible, even though it may have been the client's fault. He then came to us. So don't fall into that mistake, because the client will see it as not their mistake, but your mistake. So you've got to be careful with that. So the next issue is children tax credit, very related to the custody. So with the tax credit, obviously we need to know what the tax law is. Do we have any CPAs out here? Anyone? I was afraid of that. Maybe one back there, maybe just stretching. But I'll tell you, sometimes I think that as a divorce attorney, we all should have been CPAs, because we deal with taxes a lot. So you need to know the taxes as it relates to divorce. And the child tax credit is one of them. So we have to know the relevant tax rules. So first of all, when we're talking about child tax credit, the IRS does have a default for this rule. Is anyone aware what the default is? Yes.
If the parent has a child more than half of the year, then they get claimed if the child is tax.
Perfect. And half the year means overnight.
Repeat it, I didn't hear it.
Okay. What it is the default is if a parent has a child for more than half the year, they default get to claim the child tax credit. That is what the IRS rule says. Now, if it's split 50-50, the person that gets to claim the child tax credit is the person that is paying child support. So that's the default rule. However, the IRS allows you to overcome that default and designate something else. However, if you designate something else, you've got to do it through the IRS forms. So I've got a form here, Form 8332. Anyone seen this before? If you practice family law, I really hope you have, but it wouldn't surprise me if you haven't. Because a lot of times what happens is even if we draft an agreement that overrules this default rule, we don't think about the IRS form that needs to be filled out. So it's a very simple form. All you need is the Social Security number and the children's names. You need the custodial parent to sign a date and state what years the non-custodial parent can claim the children. So as far as IRS forms go, it's actually pretty simple. And if you fill this out, then the non-custodial parent files it with the taxes, and then they can claim that child tax credit for all of those years that are designated in there. What I'd suggest to you is when you're drafting the dissolution agreement, if you're considering having the non-custodial parent claim the children, why not have this with the agreement? If you don't have it, what's going to end up happening is your client during tax year is going to have to go to the custodial parent, get this filled out, then file it with the taxes. But you can fill this out for multiple years. And so it makes sense to get it all done up front. I'll tell you, it's avoided a lot of issues in my case. most of the cases that are highly fought over, and this is a highly fought over issue, if you deal with this right up front, the client will thank you, because they never have to go and deal with this after the fact. It makes it a lot easier in most cases. So it's nice to get that done with. And the other thing you need to consider when you're drafting the agreement is what that form, if it's your client filling out that form, what it's really giving up. So there's a lot that goes with the child tax credit, right? You're giving up, of course, the exemption, the child tax credits, but then in some cases, you may be giving up your ability to claim as head of household. Right? Now, I'm not a CPA. I don't know all the details there. So what I'll normally do is, if this is going to be an issue in a case, like I said before, you've got to do the research beforehand to get the knowledge. And so, if this is going to be an issue, I will call a CPA that I work closely with and make sure I know exactly how it's going to affect my client, how it's going to affect the opposing party. Because there are cases where this can make a big financial difference in a case. And so you want to be aware of that before you even draft the agreement so that you can take it into consideration. In fact, when you're doing settlement negotiations, you can often take that into consideration because it's going to make such a big impact. Or on the inverse side, maybe it's not going to make a big impact, and the opposing counsel is going to try and argue that. And you'll be prepared to know before in the settlement negotiations. All right, next is child support drafting considerations. So with child support, there's a lot you need to know. First, know the law and what the court's going to accept. Second, that's it. Not really it, but that's all we're going to talk about today. Because there's a lot to go over when it comes to child support, and it's extremely case specific. In fact, I was talking to one of the other presenters this morning and talking about the statute you have in Missouri that deals with child support. It sounds awful to me. And I don't want to read through it, but I'm going to tell you, you probably should. If you're practicing in Missouri, you need to know that statute. And so we're not going to take the time today to go through it, but you need to know it, and you need to do that research. So next is alimony, probably the second biggest fought over issue in divorce. Like child support, there is a lot to know with alimony. Every case is, or every state is very different in how they're going to calculate it. And so once again, I'm not going to go into a whole lot of detail when it gets to alimony, at least the state-specific issues. So what I would suggest with both child support and alimony is I'm going to give you a little homework assignment. I know that you're not in school anymore, you're probably glad you're not, but I'm going to give you a homework assignment to make sure you go read the statutes, case law when it comes to child support and alimony. Make sure you know and have that knowledge base before you try and draft a dissolution agreement. I know in Utah there's extremely specific language that will allow us to waive alimony. If that language is not in there, another party can always go and try and modify it and get alimony later. Now I'll tell you, I've seen that missing in a lot of divorce agreements, which to me is a huge red flag. So you've got to make sure that you've got the knowledge base necessary to ensure that your divorce agreements that you're drafting has everything they need to ensure your client is as well protected as possible. Now there are a lot of issues that we can talk about with alimony, so we're going to take a little bit of time and do that. Once again, back to tax. Back to I wish I was a CPA. I wish I knew a little bit more about tax. It would have been extremely helpful if I would have got my CPA as being a divorce attorney. So we have some relevant tax rules. Does anyone know the relevant tax rules when it comes to alimony? Right, alimony is a huge benefit over child support because it's tax deductible. Does anyone know the tax rule off the top of their head? Doesn't surprise me, I didn't. I had to look it up. You know it.
A dollar for dollar reduction on pay or some income, a dollar for dollar increase on receipts.
Great, thank you. So if you didn't hear that, essentially what it is the payor doesn't pay taxes at all, but the payee does. So every dollar you pay in alimony, the payor doesn't pay, the payee does. And so that's very important. That's found in Federal Tax Code 71. Yes?
pay self-employment tax on that as well. In addition to just the regular income tax, you get self-employment tax on top.
I did not know that. Did everyone hear that? I don't even know if I can repeat it. Maybe I need to come down and give you the mic really fast so that we can hear it. Because I'll tell you, it's good to have this knowledge base. I mean, as a presenter, I even learned things new. So here you go. Say that again.
Not only does the recipient of the spousal maintenance is required to pay income tax, they also have to pay self-employment tax on it as well.
All right, thank you. I really appreciate that. I mean, it's like I said, it's good to have this knowledge base, and so the more you guys want to comment, feel free. I am open to this. Like I said, this is a one-on-one course, but it's good to have as much knowledge as possible, right? And so, essentially what Federal Tax Code 71 does is it details out how we get that tax benefit, and it really defines what alimony is. And we want to make sure that in all of our divorce agreements, if we're assuming that something's alimony, we want to make sure it's clear pursuant to the IRS rules. Otherwise, that huge benefit that one client can potentially get is gone. It's got to qualify. And the next thing is the alimony recapture rule. This does not apply most of the time, but man, when it does, it hurts. And so you want to make sure you avoid that. We're going to go over the basics of the alimony recapture rule as well. First of all, let's go through the payments for alimony pursuant to the IRS rules. So first of all, the payments have to be required by a decree of divorce. So put it in your separation or in the dissolution agreement. It's got to be in there. If it's not in there, if it's just a side agreement, no tax benefit. Next, the payer and recipient spouse do not file a joint return with each other. I'll tell you, I've run into this issue a couple of times when we're dealing with temporary orders. The parties reach an agreement on temporary orders with one party paying the other, and yet they agree to file jointly as spouses, seeing that they're not divorced yet. Well, you need to remember, if that's going to happen, that whole benefit of the alimony is completely thrown out the window. In fact, I've had opposing counsels argue this on temporary order hearings, and if they don't know the tax law, it's going to hurt them. You cannot get that benefit and file jointly. Next, the payments need to be paid in cash. I've seen many divorce agreements where the benefit or the alimony is, hey, we're going to give you this property settlement. And they're trying to classify a property settlement as alimony. Or they're trying to say, oh, I'm going to pay this car off for you. And what I would suggest, don't try to be tricky. Don't try and trick the IRS. Just stick to the plain and simple. Just pay it in cash. It makes it so much easier. Just pay it in cash. And next, payment is not designated in the instrument as not alimony. Now I'll tell you, as far as IRS, I mean, they struggle in being clear. Don't ever write something like this in your agreement, please. Double negatives are killing me. It's very confusing. We're going to err on the side of caution. Just make sure you designate it as alimony. Put a header at the beginning of the clause, alimony. In the agreement, put, hey, this is what they're paying in alimony. Make it extremely clear so this doesn't even come into play. Next, they can't live in the same household. It's funny, you'd think that's a no-brainer, but it isn't always. I've had many clients that get back together even while they're paying alimony and child support. Next, the payments are not required after death of the recipient spouse. And the last is the payment is not treated as child support. So, we have some considerations that we need to think of when we're making sure that the alimony is alimony. All right? And then the next, the recapture rule. It is extremely complicated. Like I said, this is a one-on-one course. We're not going to go into the details of this, but you need to be aware of what it is. So essentially what it is this is going to apply to the payee if the alimony is reduced within the first 3 years of paying it. And if it applies, what ends up happening is the payee, he got all those tax benefits and didn't have to pay taxes on all the alimony he paid. But if the recapture rule applies, he actually has to go back and pay taxes on all of that. Essentially, the IRS is recapturing all of that tax benefit, and now the client has to pay it. So we want to avoid this. And so I would suggest that anytime you have an alimony payment that is decreasing significantly in the first 3 years, you've got to be careful. And you've got to know as well that this applies not only to divorce agreements, but to modifications. If there's a reduction in the alimony that's beyond the control of the party, say he loses his job and stops paying, it could still apply. If you're dealing with a modification of alimony, it's within the first 3 years, and you modify it down, that can apply. And so in the modification agreement, if you're doing a modification agreement, you need to be aware of this as well. That this can apply when there's a reduction in alimony within the first 3 years. So,
Does it equally apply to legal elimination?
it does. It does. So anytime there's an elimination or a reduction, you've got to be cautious. So some of the things that we need to consider to protect our clients against those in the decree. First of all, how long the payment is going to be made, right? If they're only going to be made for a couple of years, you need to be careful with that. If they're only going to be, or if they're going to be reduced significantly in the first couple of years, you've got to watch out for that repayment or the recapture rule. How is the support figure calculated? Has anyone here seen a decree of divorce that has a very complicated calculation of percentages and an equation of what needs to happen? I'll tell you, I have. Maybe it's not what happens a lot in Missouri, but man, in Utah, I've seen a lot. In fact, just Wednesday, I had an initial consultation that had one of the most complicated calculations I've ever seen. It was awful. And he wasn't even going in there to consider an alimony modification. But I sat down and I looked at this and said, all right, I know you're considering custody issues, but if you were ever to take this before the judge is going to look at that and say, what am I supposed to do with this? So you want to make sure that that is extremely clear. If you're doing a calculation, try not to make it difficult. What I would suggest is a lot better, if you can do this in Missouri, make it a strict figure that stays the same so you don't avoid the recapture rule. All right, what happens if the payee becomes self-supporting? Is that going to end payments? Is there anything else that would end payments of the alimony? All right, and remember here that one of the qualifications for the federal tax is death of the recipient spouse. So I would always suggest you've got to include that in there. What about retirement? What happens in retirement? Is it going to end there? Can you potentially modify it at that point? So next is identify whether the payments are modifiable. What I found helps a lot in our cases is designating exact things that if they occur, allows the party to modify. Retirement is one of those that happens a lot in Utah. If someone retires, we consider the modification. Next, methods for exchanging financial information each year. This is extremely important when it's potentially modifiable, but also for the next one, methods for exchanging the exact number that each person is claiming on taxes. Because of the huge tax benefit, the IRS keeps a pretty close eye on what's happening with alimony. So essentially what's going to happen is every year when the party paying taxes files their taxes, they have to claim what they've paid to a certain person on their taxes. And then the recipient spouse has to claim what they've received. Well, if they claim the wrong numbers, that's a red flag for the IRS. I can almost guarantee that the IRS is going to be sending the client a letter saying, hey, there's an issue here, let's resolve this. And so if we anticipate that before they even get to that stage and put something in the agreement to deal with how they're going to deal with that, it solves a lot of issues and a lot of problems down the line. And the last one is something that I think is extremely helpful. Define alimony in the decree. And I'd even say recite the federal tax rules right in there. I'll usually put it in there and have the parties acknowledge that they understand the tax issues when it comes to alimony and they are accepting them. To make it very clear that both parties are aware that that is tax deductible, or on the other side, that they're going to be paying taxes on that amount. All right. So, any questions, concerns when it comes to alimony? Anyone else want to add anything? This is, like I said, this is a hotly debated issue in most divorce cases that require alimony. So I want to make sure that if anyone has any questions, as long as they're not difficult, because this is 101, remember guys, feel free to ask. Anyone? Yes?
On that self-employment tax, is there a dollar cap or minimum on that?
The information I got was from a CPA for a client, and basically, the client's amount was $18,000 a year, and at that point in time, he said self-employment tax kicks in.
At 18?
Well, he said at that amount, it's going to be self-employment tax. I don't know what the lower end is, but he said at that amount, it did kick in.
All right, thank you.
Awesome. So if anyone didn't hear that, talk to a CPA. But I mean, it sounds like it might kick in after a certain amount. But yeah, talk to a CPA. Like I said, for a one-on-one course, that's even a little over my head because I was unaware of that. But rule of thumb, you've got to have that knowledge. And so when you have a case like that, you got to bring in a CPA, or at least call a CPA to find out exactly what that rule is and how it's going to affect your clients. Anything else? Anyone else? All right. So next is real property. So we've got a lot with real property that you can deal with, but essentially I think it's when you're dealing with real property in a divorce agreement, you're really talking about two separate items. Either one of the parties is going to keep the home, or the parties are just going to sell the home. So we'll talk about both of those separately. So first, let's delve into the considerations you need to take into account when you're selling the home. So, first of all, I said selling the home, I meant keeping the home. We're going to do with keeping the home first. So first of all, hold harmless provision. I'd suggest that's probably essential in a case like this. You need a hold harmless provision. And then refinancing. If one of the parties is on the loan that's not keeping the home, you've got to consider refinancing. Now, I deal with this a lot in Utah. And the reason is because in Utah, the state legislature thought they were going to help all these clients out. This divorce is expensive in Utah, so they thought, all right, what we're going to do as a legislature is we're going to set up a program. We're going to put together these forms online that anybody can go in and they can get their divorce for $30. And this program is going to fill out all these forms, and it's going to be very simple and easy. Well, the problem with that is, like I said, don't use forms. And this is a form divorce. It doesn't account for a lot of things. And one of the things it doesn't account for is this. And so I cannot tell you how many divorce modifications I've had to deal with that this is the issue. Because they think, oh, I'm going to get a cheap divorce, I'm going to do it there, and then that whole form, it doesn't even talk about this. And so in Utah, I have to deal with this so much, it's a bit of a headache to me. But you've got to consider the refinancing options. What you don't know can't hurt you. All right, so what I'd suggest, you've got to get a good relationship with the mortgage broker. A lot of times, if someone that's receiving alimony is the one keeping the home, it's very possible they're not going to be able to qualify to refinance anytime soon. You need to know that. You don't want to put in agreement, hey, they're going to refinance within the month, if that is completely impossible for them to do. And the reason for that is because when you're talking about enforcement, it's not really enforceable if they didn't have the ability to do that. I've had cases on enforcement that we go in front of a judge and the judge says, all right, well, they tried to refinance, they filed all this paperwork, they've attempted it, that's good enough. You don't want that to happen to you. That client was not happy. Luckily, I didn't draft the agreement, but that happens all the time. You don't want anything in there that could potentially hurt you. And so what you need to consider is, first of all, what does the deadline need to be? And you get that from a mortgage person. Talk to them, find out what exactly you can do, and then consider refinancing, or if they can't refinance, have some kind of consequence for it. A forced sale is what we'll normally do in Utah. Either they have a specific amount to finance, and if they can't refinance it, they force a sale. And then you also have to consider refinancing costs and determining the split of equity when you're dealing with refinancing and one party keeping the majority of the equity. one thing that I've also found that people miss a lot, and this may be because before I became an attorney, I did a lot of title work, and I worked with a title company. I owned a title company for a while. So I know a lot about title insurance. And what happens a lot of times when there's not a loan, so there's not a loan issue to deal with, or the person keeping the home is the person that's solely on the home, everyone thinks, well, that's a great scenario because all we've got to do is a quitclaim deed. Wrong. Don't do a quitclaim deed, please. What a lot of people don't realize is that a quitclaim deed will cancel the title insurance policy in most circumstances. It's very rare that it doesn't. And so you've got to make sure that if that's what you're doing, you're deeding it from one party to the other, don't do a quitclaim deed. That doesn't provide the protection needed, and it can potentially cancel the title insurance policy. So do a warranty to make sure that that's protected. All right, the next consideration is with selling the home. There's also a lot to deal with selling the home, and a lot to consider. First off is choice of realtors. Getting an appraisal, sell price, choosing an offer, profit and loss. What happens if we can't sell it? Are we going to foreclose? All right, those are the basic factors of what to consider. I'll tell you that I had a case probably about a year ago now that we had to go into such detail here just to ensure that the clients didn't have an issue. They fought over everything. And so when we talked about choice of realtors, we went into extreme detail. I mean, there was probably 2 or 3 paragraphs on just how they would choose a realtor. There was 2 or 3 paragraphs. We didn't do an appraisal, but the sell price. How was that sell price going to be determined? All right. There was a very lengthy section about choosing an offer. All right. These are things that you want to consider, and once again, the more detail possible, the better, because if you have the detail, it's going to avoid issues. So make sure you've got that detail. All right, next is financial accounts. So, has anyone here dealt with a case where either your client is hiding money or they're claiming that the other side is hiding money? Anyone done that? Yeah, I feel like that happens to me all the time. Somebody's always hiding something. It is difficult to deal with. And I think if you practice long enough, it's guaranteed that that's going to happen. Somebody thinks that somebody's hiding something. So we want to make sure that we, once again, do the discovery to make sure we have the information needed. What I would suggest is the best way to do that is pull a credit report. Especially when it comes to debt, that's all going to show up there. I had a case that my client pulled his credit report, like I always do in cases, and he came to me and said, Doug, there's a $25,000 credit card that I know nothing about. And I rolled my eyes and thought, oh great, what are we going to do? It was difficult. Sadly, my client had to pay half of it because it was marital debt. But that was a lot better than having to deal with it after the fact. And finding out, oh great, there's all this thing, all this debt that no one's disclosed and we just found out about. And now, even though we've already negotiated an agreement, we've got to go back and we've got to completely renegotiate because there's this huge debt that was not disclosed. So you want to make sure you have the knowledge you need. And the easiest way, in my opinion, is to pull a credit report, at least for the debt. Everything else, you're probably going to need extensive discovery if they're hiding something. Other items or terms to consider. Are we closing the accounts? Is one person on account? Are both parties? If there's any debt associated with the account, can we even close it? Most agencies won't allow even one party's name to be removed unless there's zero debt associated with that account. So you gotta be aware of that and know that. Next, in my opinion, is a must, a disclosure provision saying that there's no other assets. Then if someone is hiding it, usually they're going to be dinged if that's ever found out. Next, indemnification clause. That's always something you need to consider when you're drafting these. And the last is a non-dischargeability clause. I'll tell you, I had a hearing on Tuesday of this week that was dealing with a case that The client, he was divorced 5 years ago, and 2 months after the divorce, he turned around and filed for Chapter 13 bankruptcy and discharged all the debt he was awarded in the divorce. Man, does that cause issues. 5 years later, we are still litigating that issue because it wasn't dealt with in the decree of divorce. And to be honest, he anticipated it. He knew at the time of settling the agreement and drafting the agreement that he was going to file for bankruptcy. And so if you know that or have any inclination that a bankruptcy could potentially occur with these clients in the future, which means most of the time if there's a lot of debt, you've got to be careful of this. You want to consider a non-dischargeability clause and have a very frank discussion with your client and in negotiations about how you're going to deal with that beforehand, which means in the agreement. You want to consider that and take that into account. If this client's original attorney had considered that he was going to file a bankruptcy, which, like I said, he knew at the time of this divorce that he was, if they would have considered that and dealt with that at the time of divorce, I would not be representing that client now. That would have been all resolved, and it would have saved my client thousands upon thousands of dollars. But instead, we're still litigating that case. So you really want to be cautious with the non-dischargeability. Next, personal property. So with personal property, it's one of my pet peeves as well. Because what happens a lot, I feel, especially seeing as working with Cordell Cordell, we represent a lot of men. I find what happens with men is they say, I didn't buy it, I don't care, she can have whatever she wants. Don't do it. Don't write that blank check. There is so much value in a personal property that you really have to be cautious. And there's a lot to deal with in the personal property. So you want to make sure that those are dealt with very well. So don't write a blank check. If it's significant valued items, you have to consider an appraisal before you draft the agreement. And the next is be specific with everything that needs specificity. I feel like I keep harping on this, but you got to be specific. You got to be specific, right? We're dealing with a case right now in Utah that what ended up happening is they had an agreement, they were divorced 3 years ago, and the agreement essentially said both parties are going to keep what's currently in their possession. Well, what wasn't disclosed in the whole divorce agreement is that the parties had about $150,000 worth of silver coins. And now we're litigating over the fact that there's some question as to who had those coins in their possession at what time. And so we're doing a whole blown out litigation about what needs to happen with these with these coins after the divorce. Once again, if this was dealt with and was specifically listed in the decree of divorce and in the divorce agreement, never would have gotten to this stage. It wouldn't have happened. A lot of, like I said at the very beginning of this, a lot of the cases that I've been doing on modification are cases that could have been avoided. That case could have been avoided if they